Mr. Speaker, I rise today in support of H.R. 1044, the Fairness for High-Skilled Immigrants Act, a bipartisan bill that would make a modest but important change to our immigration laws to alleviate hardships associated with lengthy visa backlogs. Let me begin by explaining what this bill does do and does not do. H.R. 1044 does not increase the overall number of immigrant visas that are available each year. Although raising the ceiling on visas is the only viable way to eliminate backlogs, there is, in my view, unfortunately, no consensus on that issue at this time. But there is broad consensus that we should do what we can to make the system more equitable. This is the focus of H.R. 1044. By eliminating the per-country limit on employment-based visas, all immigrant visa applicants will eventually be restored to a level playing field, where one's country of nationality has no bearing on their place in line. Under our immigration laws, employment-based visas are granted to individuals under a 5-tiered preference system. The first 3 preference categories are reserved for priority workers, individuals with advanced degrees, and other professionals and skilled workers. To be eligible for a visa under one of these categories, the applicant must generally have an offer of employment from a U.S. employer and must submit extensive documentation of their qualifications for the job in the relevant preference category. The applicant's country of birth is simply not a factor, and rightfully so. What does a person's nationality have to do with their merit as an employee? However, country of birth does become relevant after the applicant has qualified for a visa and is waiting in line for a visa number. The so-called per-country limit prohibits any one country from receiving more than 7% of the immigrant visas that are available each year. Because of this, the visa backlogs have a particularly harsh impact on nationals of countries with high populations, and thus high demand for visas, such as India. As a result, it can now take a decade or more for an Indian physician working in a medically underserved area or a particle physicist with a PhD from MIT to receive a green card. How is this good for our country? Our immigration system is in desperate need of reform. We all know too well the plight of dreamers and the undocumented population. We know now more than ever that our agricultural sector, which relies heavily on immigrant workers, is struggling to satisfy its labor needs and provide a safe domestic food supply. We're reminded daily of the concern we have of the situation unfolding at the border. On top of these very real and very serious issues, we also remain inextricably bound by the imperfections of an immigration framework that was formulated nearly 30 years ago and is out of touch with the needs of the 21st century. Major reforms are required to truly fix our outdated legal system, but as we all know, such reforms have been hard to come by for a long time. If we want to get anything done, if we want to do what's right for our country, we have to find common ground and we have to compromise. On an issue as contentious as immigration, our failure to work together in a fully bipartisan fashion can only result in legislation that will go nowhere in the Senate. H.R. 1044 is one of those rare proposals where we can agree. 1044 has strong bipartisan support with more than 200 Democratic and more than 100 Republican co-sponsors. In 2011, the House passed a version of this bill by a margin of 389 to 15. I urge all of my colleagues to once again vote in favor of this bill, and I reserve the balance of my time.